This week, the International Court of Justice completed its public hearings on Israel's obligations to facilitate aid to Palestinians, specifically aid that's delivered by international groups, including the UN, as well as by third states. For over 2 months, Israel has completely cut off all aid supplies to the 2.3 million residents of the Gaza Strip. Israel has repeatedly said it will not allow the entry of goods and supplies into Gaza until Hamas releases all remaining hostages. It has accused Hamas of hijacking humanitarian aid, which Hamas denies. During the election campaign as Liberal leader, Prime Minister Mark Carney posted on X, quote, "The UN World Food Programme just announced that its food stocks in Gaza have run out because of the Israeli government's blockade. Food cannot be used as a political tool," end quote. Canada was not one of the 38 countries presenting a legal argument this week at the ICJ. Nathan Derejko is the Mauro Chair in Human Rights and Social Justice and an Assistant Professor of Law at the University of Manitoba. Good morning, Nathan.
Good morning.
So, Nathan, under international law, what obligations does Israel have towards Palestinians in Gaza, specifically when it comes to providing humanitarian aid?
Well, this question can be asked from multiple bodies of international law. Human rights law contains obligations for Israel, public international law. But if we look at it from the perspective of international humanitarian law, which is the laws of war, the laws of armed conflict, there's a general obligation that is applicable to all types of armed conflicts. And it's for the parties to provide food aid, medical aid, and other objects indispensable for the survival of the civilian population when civilians are in need. Now, in a situation of belligerent occupation, where one state occupies the territory of another or occupies foreign territory, this obligation is more nuanced. It becomes categorically. If we look at the provision, Article 59 in the Fourth Geneva Convention, we see that the occupying power shall agree to provide aid to civilians in need where there's an insecurity of food or medical aid, and it shall take all steps necessary to facilitate that aid. This wording differs from the other provisions in international humanitarian law and provides a categorical obligation where there's no loopholes or no uncertainties as to the nature of the obligations.
Can we talk about something you said that when there's a belligerent occupation? So Israel might make the argument that it's not an occupying power in Gaza when it kind of withdrew its presence from Gaza in 2005. Talk to me a little bit about how Israel is considered an occupying power under international law.
Yeah, so the law of belligerent occupation is scattered across numerous treaties for the past 100 years. But the definition of when territory should be considered occupied is contained in the 1907 Hague Convention. And it speaks of when territory is placed under the hostile armed forces, under the authority of hostile armed forces or effective control. And so in 1907, the way that a state would exercise effective control or have exercise authority over territory is by having boots on the ground. But in the last 100 or so years, we've seen that there's other ways. So this question of post-2005, whether Israel is still an occupying power in Gaza, has been examined by numerous international commissions of inquiry, the International Court of Justice. And if you look at what they do is they take a look at the facts. They say, like, the Gaza Strip is hermetically sealed. Israel controls the airspace, the border space, the sea space, and conducts surveillance operation. Within the Gaza Strip, Israel controls what goes in, what goes out, and imposes customs and tariff duties on everything coming into it, and controls construction supplies, which dictates what can be built, what can't be built. It controls the population registry. If Palestinians want to get an ID, it has to be approved by Israel. The currency is the Israeli shekel. They tax and impose duties on things that come in and out. And everything that happens in the Gaza Strip is controlled by Israel. So, of course, as recently as 2024, in the ICJ's advisory opinion, the International Court of Justice came to the inescapable conclusion that, yes, pursuant to the idea that a belligerent occupation is the exercise of authority and effective control, Gaza remains occupied by Israel. And this is shared by the International Committee of the Red Cross, human rights organizations all over the world.
You read over Israel's written submission to the ICJ. What were its main arguments for preventing aid from entering Gaza?
Yeah, I did. There was three arguments that Israel presented. The first was about why the ICJ should decline to give the advisory opinion, which was procedural and technical. And then the other two, one was on that UNRWA has been infiltrated by Hamas and is no longer neutral and partial. And the third argument was these technicalities on international humanitarian law. So let me just briefly speak to the last two. In terms of UNRWA and its infiltration by Hamas, and, there's a whole broad range of allegations alleged by Israel on that, UNRWA's members are all Hamas members. It's a front for Hamas. The UNRWA facilities are weapons and command and control centers. We're all familiar with the allegations. But I think what we haven't seen is the evidence to support the allegations. And I think there's a powerful vindication too recently. First, all of these allegations were, again, repeated verbatim, basically, in the Israeli submission to the ICJ, but there was no evidence to support them. They were just listing opinions without any supporting evidence. Second, if we look at when Israel first made the allegations that a number of Hamas members were part of the attack on, a number of UNRWA members were also Hamas and part of the attack on October 7th, a number of states temporarily suspended aid. And now we've seen, until there was an investigation, the UN had a series of procedures that immediately went into investigate it, produced a report. Following the release of that report, a number of almost every single state that temporarily suspended aid, reinstated aid, and even increased aid, which I believe is testament to that there was no factual evidence to support these allegations. So there are procedures in place if that happens, when it happens, and how it's dealt with. So we'll just leave that one there. The second one is Israel said that it can't be forced to cooperate and work with an entity that it believes, is prejudicial to its security and national security interests, and that everything is predicated on consent. This argument's more nuanced within international law, but it doesn't hold much water in this context for two reasons. First, it's true that everything in international law is predicated on consent. States have to consent to be bound by treaties. Humanitarian operations usually have to require the consent of the territorial state. Now, the first problem here is that, as emphasized most recently in the ICJ advisory opinion 2024, Israel does not exercise any sovereignty over the occupied Palestinian territory whatsoever, and therefore has no sovereign rights in the Gaza Strip, West Bank, or in East Jerusalem. So there's no consent necessary for Israel does not need to provide consent for those territories because it doesn't exercise sovereignty over them. Second, the rule on consent of the territorial state for humanitarian relief has two exceptions, which didn't emerge in the Israeli brief to the ICJ. The first one is when there's a Chapter 7 Security Council resolution that authorizes aid in the absence of consent of the territorial state. The last time we saw this, which might have been the first time, is 2014 or 15 in Syria, when the Security Council authorized aid to be delivered via Turkey into Syria without Syria's consent. The second exception is during situations of belligerent occupation. There's no need, and this is because of the categorical wording of the text of the obligation in the Fourth Geneva Convention, but also because of what the object and purpose of that provision is to prevent a belligerent occupant from starving the civilian population or using starvation as a method of warfare to force its adversary into submission, right? You can't wage war against civilians to try and get to an adversary. That is the whole basis of the prohibitions contained in international humanitarian law.
So that idea of not allowing aid into Gaza in an attempt to pressure Hamas into releasing hostages, is that collective punishment, which is a war crime?
Yes, that is the textbook example of collective punishment, and it's the textbook example of weaponizing food and using starvation as a method of warfare.
Canada has not submitted any arguments in these particular hearings. What was your reaction to that?
Yeah, it's twofold, really. Canada usually engages the ICJ. Canada loves to present itself as, a supporter of international law and human rights and the rule of law and global justice. But then, so it's quite surprising that it chose not to engage when numerous other Western states, Southern states, states from across the world are engaging in the process. But then it's pretty much par for the course with Canada's stance on Palestine and Israel in particular. So I wasn't very surprised with it. What was more surprising is that two states who reject the court and consistently rage against it, the United States and Israel, both engage the process in either written or both written and oral submissions. So that's a bit unique in the sense of we never agree with the court, never agree with its jurisdiction, but hey, I need to, register so I can submit a hearing, both written and oral. The problem for Canada is, I think, when in the context of Palestine-Israel, Canada has failed consistently on all of its obligations in numerous bodies of international law. We see this with the ICJ provisional measures on genocide, South Africa versus Israel, where the court ordered all states to use all leverages basically at its disposal to prevent a plausible genocide from occurring. Canada hasn't, in my opinion, used any of those leverages. Under Article 1, common to all 4 Geneva Conventions in international humanitarian law, every state has an obligation to respect and ensure respect for international humanitarian law. Those are both positive and negative obligations, which means Canada should be taking positive action, such as stopping arms shipments reaching Israel from Canada. And then we see again today, we see this lack of engagement in the international judicial process and the diplomacy of the issue. And I think what's interesting is Canada, is up for a seat at the UN Human Rights Council, the 2028-2030 seat. Canada is going to put forward its official candidacy in a system that it's consistently not participating in, is remaining silent, remaining on the fence, when Canada knows its obligations are clear and it takes a stand. Now, recently, Mark Carney, took to Twitter to talk about how, Canada would start to begin to stand up in international law and take positions where other states are taking a seat. And I'm wondering, is this just political rhetoric so Canada can move towards getting that seat at the UN Human Rights Council? Or are we going to see a shift in Canada actually acting on its international obligations?
The ICJ have been tasked to form an advisory opinion as a result of these hearings. What impact will a non-binding advisory opinion have on Canada with regards to aid entering Gaza?
I think it can have whatever impact Canada wants it to. It depends on the political will. It can serve as the legal basis of all of our legal actions and policy actions moving forward in terms of demanding aid be entered, and then taking the lead and just delivering aid through the Mediterranean Sea, for recalling ambassadors, putting on economic sanctions, two-way arms embargoes. All of these things could be predicated on that judicial opinion, or Canada could do what it has done previously and just totally disregard them all, be in breach of its own obligations, and kind of wait for litigation, whether it comes from within or from without Canada. But I think whatever Canada does do with this obligation, the world is watching, and it has implications beyond Canada. Again, Canada wants that seat at the UN Human Rights Council, and the last time when Canada went up for a seat to the Security Council, it didn't get the seat, because I think other states saw this, hypocrisy and double standard of Canada says A, B, and C on the international stage, but it doesn't meet it with any action. But it's also important to remember that this ICJ advisory opinion will have reverberating implications within the UN itself, right? There's general obligations within the UN Charter for states to give all assistance to the UN in the execution of a mandate, including UNRWA, right? UNRWA was created by the General Assembly in 1949, I believe, and its mandate's been extended every year or every few years ever since. So Israel is in breach not only of various internal and substantive provisions of the UN Charter, but in breach of binding orders from the ICJ. And so question becomes now, what happens when a state consistently breaches the Charter of the United Nations and basically disregards the judicial proceedings of the main judicial organ that's sent to oversee the UN Charter? And so there's a whole range of options, ranging from, temporary suspension of voting privileges in the GA, or suspension from the GA of Israel until its compliance with international obligations under the Charter. So there'll be other things, and Canada will have to vote on these things again within the General Assembly. And so its position will have to come out at one point or another.
Nathan, thank you so much for coming in and breaking this down for us.
Thank you for having me.